In the case of Heart of Atlanta Motel v. U.S., the Supreme Court upheld the constitutionality of the Civil Rights Act of 1964. However, conservatives have always opposed it, and conservative Supreme Court justices have consistently voted to limit it and other civil rights laws in many ways. We have already seen, for example, that conservatives on the court ruled that victims of paycheck discrimination only had 180 days from their first paycheck to file a lawsuit. Congress overturned that decision by passing a new law. In 1984, conservatives on the court also limited the Civil Rights Act by ruling that if a part of an institution commits racial discrimination, only the part that discriminated can be held liable. Congress also overturned that decision by passing a new law, the Civil Rights Restoration Act, that said an entire institution is liable if any part of it engages in racist behavior. Now that the Supreme Court has a clear conservative majority, it will almost certainly issue many more rulings that will make it more difficult or impossible for victims of racial and other forms of discrimination to have their day in court. In fact, it has already begun. Jane Cummings was both deaf and legally blind. She needed physical therapy, and so she contacted a rehabilitation company, and she asked for an interpreter to be present at her therapy sessions. The rehabilitation company refused, and so Cummings filed a lawsuit under the Affordable Care Act and the Rehabilitation Act, both of which forbid such discrimination and allow victims to bring lawsuits. In April 2022, Cummings lost her appeal to the U.S. Supreme Court. Like so many decisions in the court's October 2021 term, this was a 6-3 decision, with all 6 of the conservatives voting against Cummings, and all 3 liberals voting in her favor. The court did not strike down the law as unconstitutional. Rather, they interpreted it in a way that made it impossible for many victims of discrimination to sue. The court admitted that Cummings was a victim of illegal discrimination. They just ruled that there was nothing she could do about it. Some victims of discrimination suffer economic damages. For example, if a worker is fired from their job, they suffer economic damage in the form of lost wages. Many other victims of discrimination don't suffer any economic damage. For example, Rosa Parks did not suffer any economic damage when she was refused a seat at the front of the bus. Similarly, Jane Cummings did not suffer any economic damage when she was refused an interpreter. However, the law has traditionally allowed such individuals to sue for the emotional distress such discrimination causes. In Cummings v. Premier Rehab Keller, the court ruled for the very first time that the law only permits individuals who actually suffer economic damage to sue. If a victim doesn't lose any money, then they cannot file a lawsuit, no matter how egregious or embarrassing the discriminatory treatment was. For example, there was another case in which a young girl was sexually harassed by her teacher. Under this new Supreme Court ruling, she would not be permitted to bring a lawsuit against him or the school district, because she had not suffered any economic harm. Similarly, a lawsuit filed by a young black student who had suffered racial discrimination and assaults for more than 3 years would have their case tossed out, because there was no economic harm, only physical and emotional harm. For victims of discrimination, there are 3 possible solutions. First, Congress could pass new laws clarifying that lawsuits for emotional harm are permitted. But any such law would require 60 votes in the Senate, a nearly impossible task in America's highly polarized political climate. Second, individual states can pass their own laws allowing such lawsuits, and many have already done so. But this does nothing for victims of discrimination in states without such laws. Finally, the Supreme Court could overrule its own decision, but with a young, conservative majority on the court, that won't happen for decades, if it ever does.